Good afternoon, or good evening, Mr. Schulman. Again, my name is Jim Matthews. I'm a lawyer with Baker Dublicar, law firm in North Canton, 400 South Main, resident of Alliance, Ohio. I'm here on behalf of the applicants, the TowerCo applicant, seeking the easement that's at issue in this matter. In light of what I've heard thus far this evening, I think it's important that we take a step back and actually address what it is that's under consideration before this body. Many of the issues, if not all of the issues that you've heard from opponents to the tower project itself, are matters that have already been aired in front of the North Canton officials. As each of you, I believe, is aware, the tower location in question is actually within the jurisdiction of North Canton, which meant that the permit process for proceeding with this tower went before the Planning Commission and Board of Zoning Appeals within the city of North Canton. It is important for you to also be aware that there was a direct appeal taken by the Homeowners Association to the Board of Zoning Appeals in North Canton, challenging the issuance of the permit for this tower to proceed. Many of the issues that you've heard, sort of these generalized health concerns, generalized property value concerns, and the like, those are all matters that, quite frankly, and this may sound harsh, but quite frankly, those matters are not justiciable, even at the local township or city level of permit procedure, because those issues are preempted under the Federal Telecommunications Act. But to the extent there is any local regulatory authority through the zoning officials, that matter again was handled all in the city of North Canton. My client has a lawfully issued permit and plans to proceed as soon as it can with its tower project in North Canton. So what are we here about? We're here about seeking an easement across a small sliver of property that your city owns that extends on the west side of Market, and it, importantly, is property that is held only for highway purposes. Part of the evidence that had been introduced in the North Canton procedure was the appropriations proceedings relating to the acquisition of that property, and it was very clear that the only reason that the city acquired that property along Market was for highway purposes. The easement that we're talking about would be a 20-foot easement. I believe the paperwork has been provided to you, and not only the proposed ordinance, but also the proposed easement that includes the property description for the easement. This will be for utility installation only. That's the sole purpose for the need for the easement. It will be utilized by boring procedures. In other words, there will be no disturbance of the surface. These underground utilities will be installed through a boring procedure without interfering with any of the existing structures or topography in the sliver of property that we're talking about. The one item that we've heard some about concerns the issue of the drainage problems or drainage issues that the city is encountering, which is along the drainage area there to the south of the church property. I do understand there are some drainage concerns. Those, however, are concerns that need to be addressed in some other fashion and have no bearing whatsoever on proceeding with my client's tower project. I heard earlier from one of the opponents that as part of the City of North Canton procedure, someone from the engineer's office appeared and made a presentation. I have the transcript of that proceeding, and indeed there was an assistant city engineer from the City of Canton who did attend the North Canton procedure. I had the opportunity to cross-examine Mr. Barnes, and Mr. Barnes made it clear that he had made no calculation whatsoever of any problem that would be encountered by the installation of this tower in terms of increasing any runoff or concerns to the drainage to the south. And moreover, when I finalized my cross-examination of Mr. Barnes, after pointing out that he had made no calculations and that at best the effect of drainage from the cell tower installation is negligible, he makes it clear here that he had no concerns about the development of the cell tower. He only appeared at the hearing to mention the fact that there are drainage concerns that will have to be resolved or addressed in some other fashion. It has nothing to do with this particular project proceeding. It is my understanding that the city engineer's office has had a communication, a dialogue with representatives from my client to place this particular easement in a reasonable location. There was an initial proposal that had the proposed easement a bit farther to the south on Market. An accommodation was made to move the easement to the north at the request of the city engineer. And then we received an email, my client received an email from the engineer's office indicating that that location would not interfere with any possible future detention basin expansion in the south. So again, the placement of this easement that's going to involve underground installation of utilities will have no effect on any of the drainage work that may need to be done in the future. As part of the packages that were distributed some time ago, we included not only our correspondence with the law director's office, but also some provisions of state law dealing with the easements for utilities within public rights-of-way that are held for roadway purposes. If you've not looked at that law, if you've not made any inquiry of your law director's office about the law, I would like to spend just the final couple of moments and comment on that law. The law is very clear in a series of statutes that the general overlying or underlying public policy expressed by the General Assembly is to expand access to utilities and to expand economic development by allowing utility easements within public right-of-ways. So we start with that very broad and very clear expression of public policy. There are then very few exceptions for deviating from that public policy to allow for an easement within a public right-of-way to be rejected. Also importantly, with regard to municipal corporations such as Canton, state law is absolutely clear that a municipal corporation shall provide public utilities or cable operators with open, comparable, non-discriminatory, and competitively neutral access to its public ways. I won't bore you with the rest of the provisions, but I think the strength of that position is absolutely clear. In my mind, there is no legitimate. That's not to minimize the things you've heard. I understand the expressions of generalized concern. Those are matters that were properly addressed before North Canton planning officials, and they've been dealt with in a final determination. But those matters aside, what's in front of this council dealing with the application for the easement across a public right-of-way, it is my position that the law very clearly allows my client this access, and we would very much appreciate it if you would proceed to allow this project to advance. Mr. Chairman, if there is a public hearing on this issue later, I do have client representatives here for the members of the City Council if there are any particular questions at that time.
It's fine, Mr. Matthews. Thank you so much.
Thank you.
Anything else?
That is all. Thank you.
We appreciate your patience. Thank you very much, sir.